Hello and welcome to Law and Democracy, a podcast of the program on election law at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law Program, and today I'm delighted to be joined by Ned Foley, the Director of the Election Law Program, as well as a number of fellows and senior fellows of the Election Law Program, including Tony Goggin and Ann Ralph and Matt Cooper. And we're especially delighted today to also welcome back as a guest on our podcast, Dakota Rudisil, who's an associate professor here at the OSU College of Law with special expertise in national security related matters. And we've invited him back today because of the questions that are percolating at the moment concerning the president's control of military forces. It is June 17th, just after 10 a.m. Eastern Time, when we're recording this session, and we wanted to be clear about that because the issues that we look forward to discussing today with Dakota are rapidly evolving. So with that as context, I'm going to invite my colleague Ann Ralph to sort of cue up our discussion a little more concretely and pose an opening question for Dakota.
All right, thanks, Steve. Dakota, let's start by just sort of laying the groundwork for understanding everything we're going to be talking about today. What is the legal architecture that governs the president's use of military force domestically? What is the architecture of that law?
Yeah, well, thanks. And these issues are not only in front of us whenever we look at the internet or talk to our neighbors, but very much relate to law and democracy. So I'm glad that we have some time to focus on this. So I'm just going to kind of just briefly sketch out the constitutional statutory framework for domestic use of force, and then we can dive into particular issues. So just at a very overall macro level. So the Constitution and our legal order separates out generally civilian law enforcement and the military, the national security apparatus. And some of the legal authorities we'll talk about can definitely have that end up blended, but that's the default, right? Like we don't, if somebody is accused of stealing a candy bar, you don't have to deal with the Army or the CIA, right? Second, we have default separation between the federal government, which under the Constitution is a government of limited powers delegated by the people in the states under the Constitution, and then the states, which have the police power, just kind of general power with regard to law enforcement and the welfare of the people and whatnot. So that's the architecture. And again, that architecture can also get modified by the laws that we're going to talk about. So the federal government has some important but limited powers when it comes to civil unrest, domestic use of force, things of that nature. So, federal civilian employees can obviously enforce federal law within the United States. And for example, in the recent events, we've seen ICE doing that. We've seen Customs and Border Patrol doing that, right? So federal civilians can enforce federal law within the United States. The National Guard and what I'm going to call regulars, military regulars, which is people often talk about the active duty armed forces. I'm going to use the kind of geeky military term of regulars, meaning they are the regular constituted standing army, if you will, of the United States. So the National Guard and federal regulars, under some circumstances, can, but usually not. But we'll talk about that.
Just to be sorry to interrupt, but just so some of our listeners, the National Guard is not the regular armed forces. Those are two different buckets you're talking about, correct?
That's correct. Yeah. So the National Guard is what under federal statute is called the organized militia. It is the so the militia, as understood by the framers, is basically the military age armed citizenry under statute. It's also basically the military age men. And so the National Guard is a professionalized, organized militia force. and as a default is subject to call by state authorities, subject to state law, but under the Constitution can be put on federal duty, and then is subject to direction by the commander-in-chief. And at that point is a federal force. When the National Guard is put on federal duty, it is a federal force bound generally by federal law about federal about military forces that also apply to the standing Army, Navy, Air Force, Marines, Space Force, right? The regulars, if you will, right? Okay, so in the Constitution, I want to flag 4 parts of the Constitution very briefly that are relevant here. So in Article 1, Section 8, there are 2 militia clauses, Clause 15 and Clause 16. Clause 15, the first militia clause, says that Congress, via statute, can provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasion. So Congress can give the president the authority to call forth the militia. If the Congress does not do that, the president cannot call forth the militia to federal duty. And again, the National Guard is the modern, professionalized, organized militia, right? Congress can decide not to do that. Congress does not have to give the president authority, and the Congress can put pretty much whatever conditions it wants to on that presidential ability to call forth the National Guard. So Clause 16, the next Article 1, Section 8, Clause 16, gives Congress expansive authority over organizing, arming, disciplining, and governing the militia. So basically what that means is, with just kind of one other exception that's not relevant here, Congress can exercise via statute pretty much total control over the militia forces that it is providing to the president to be mobilized if the president decides to do that, right? So it's extremely expansive. Okay, the next constitutional provision I just want to touch on briefly is what's sometimes called the guarantee clause. It's often neglected as part of these conversations, but I think it's an important one. So Article 4, Section 4 of the Constitution says that the United States, meaning the federal government, shall guarantee to every state a republican form of government, meaning not a dictatorship, not a monarchy, and shall protect each of them against invasion. And then this is the especially important part. And the federal government, on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. So the federal government shall protect the states against domestic violence, civil disorder, violence within a state, if the state requests that help, right? Next, going back to Article 1, Section 8, there's Article 1, Section 8, Clause 14. That says Congress shall have the authority via statute to make rules for the government and the regulation of the land and naval forces. And as I've explained in my scholarship, this basically means 2 things. One is the regulation part. Congress can write the military's justice code, the UCMJ. And then there's the govern word, which essentially means that Congress can write rules for governing the armed forces, right? Putting restrictions on what they can do operationally outside the gates of the base. And that applies to federal regulars, but also the National Guard if they're on federal duty, kind of secondarily. Next, we have, and the fourth and final constitutional provision I want to flag right now is Article 2 of the Constitution, which is about the presidency. And Article 2 makes the president the chief executive and vests that person with the executive power to execute the laws, implement the laws, and makes the president the commander-in-chief of, and the way that it's worded, it's commander-in-chief of basically the federal regulars and the militia, today meaning the National Guard, when on federal duty, right? So it's not commander of the country, like the Roman emperor was commander of the empire. It's commander of the armed forces that are on federal duty, okay? All right, so the statutory framework that is relevant to domestic use of the armed forces that Congress has written pursuant to the constitutional provisions that we've talked about, I'm going to flag 3 things here very, very briefly. So first of all, there's what's called the Posse Comitatus Act. So the Posse Comitatus Act has fascinating origins that I won't dive into right now, but basically what it does is it operates as a default ban on federal military forces doing law enforcement. And this reflects the separation of, right, law enforcement generally as a civil matter, right, civilian matter, right, and the military. That's the default, right? And this applies to the entire federal military. So that's the standing regulars, all of them, and the National Guard when it's on federal duty as a default matter, right? There are a small number of exceptions to posse comitatus. The main one is another statute that many folks have probably heard about, which is the Insurrection Act. So the Insurrection Act is a collection of statutes, parts of which date to the founding and other places in the 1800s, that allows the president to call out the militia, meaning mainly the National Guard, and or federal regular forces to execute the laws. And so it would allow them to do law enforcement if there are rebellions, insurrection, opposition to state authority or to federal authority. And there are a number of different provisions. We'll set the details aside for now, but so basically the Insurrection Act is a exception, again, to posse comitatus, which would allow federal armed forces to do law enforcement within the country. The statute has a number of problems, which we can talk about later, but it's the language is written very broadly. It's confusing. I think it has a problem, many of us do, under the guarantee clause of the Constitution that I just mentioned, but obviously an important statute. The last statute I'll touch on right now is the one which is currently being litigated, and at noon today will be the subject of a hearing in the Ninth Circuit, and that is 10 U.S.C. 12406. So this is a statute which has gotten far less attention in recent years than posse comitatus or the Insurrection Act, and even some other statutes that I haven't touched on. But it's an important one. So 12406, I think, is probably best viewed as basically a 1900s and obviously 2000s successor to founding era statutes that that reflected Congress pursuant to its militia clauses power, giving the president authority to call forth the militia, which is now the National Guard, right? But this law itself, the statute, when you trace the legislative history, it mainly goes back to the very early 1900s when Congress was making a lot of changes to the National Guard and to the armed forces. And so what 12406 says is, so 12406 basically has kind of two big pieces to it. So one is what we could think about as the substantive criteria. So 10 U.S.C. 12406 says that the president can call into federal service members of the National Guard in three circumstances. If the United States is invaded by a foreign nation. Second, there is rebellion or danger of a rebellion against the federal government, so not states, federal government. Third, the president is unable with the regular forces to execute the laws of the United States. So those are the three criteria. Meeting any one of those three is sufficient. And then there's a procedural element to 12406. And here the statute says, orders for these purposes shall be issued through governors of the states. So there's one other piece of this. Well, actually, so let me talk about the president's memo of June 7, just briefly. As folks know, from reading the paper and the internet and whatnot, right, that the Trump administration has been very aggressively rounding up migrants, immigrants, and there's been a response to that in a number of places, especially Los Angeles, with people turning out on the streets, expressing a lot of unhappiness directed at ICE personnel. And we can talk about the kind of the factual details here more if we want to in just a moment, but just suffice to say that it's been a combination of plainly First Amendment protected free speech and some civil disorder, including throwing water bottles and some pushing and shoving and burning some cars and some other things of that nature on a limited basis, but in a number of cases pretty intense. So President Trump responded to that. With a directive that he issued on June 7. And what he did is he invoked the statute that I just talked about, 10 U.S.C. 12406, to do two things. First of all, he put members of the California National Guard on federal duty. Initially, it was 2,000. That's now been expanded to 4,000. And in one sentence in the directive, also gave the Secretary of Defense authority to put federal regulars into the field as well, to do what is basically protective work. And so this gets to what's sometimes called the protective power. And this is pursuant to the president's Article 2 authority as chief executive to take care that the laws are faithfully implemented, and basically to protect federal property and federal personnel. It's a very contested authority. It is one that is real. But pursuant to that now, the president has, or the Secretary of Defense has mobilized 700 Marines, and they're in Los Angeles and protecting a courthouse there and reportedly did a detention. So a lot more we could say, but that kind of brings us up to June 7. The president did that. Governor Newsom of California challenged this in court on the rebellion criteria, on the process that the Defense Department and the Trump administration used to mobilize these forces, and won at the district court level, and now that's on appeal to the Ninth Circuit. So that brings us up to the hearing coming up at noon today.
So Dakota, can I ask, in light of all of that, which is a rich narrative about a number of moving parts here, what do you see as the largest legal issue that looms out there, if you had to pick one?
Yeah, well, so with the current litigation about 12406, I really think that there are kind of two pieces to this. And I think ultimately neither of them are going to be probably resolved in a direction that Governor Newsom of California would like. Although he did, he in the state of California did win at the district court level. So on the rebellion criteria, basically the governor was arguing that the disorder that we've seen in California doesn't amount to rebellion under the statute. It's something more just like a combination of First Amendment protected free speech and expressive conduct, some civil disorder, some amount of crime, right? Which is not like a rebellion. So what's a rebellion? And there's some case law here that suggests that once Congress has provided the president with authority via 12406 or other statutes, right, to use forces and do things, deciding what meets the definition in the statute, if the terms are undefined, is really up to the president. And when you look at 12406, there's no definition in the statute of what is rebellion. In the same way that under the Insurrection Act, there's no definition in the Insurrection Act of rebellion, insurrection, opposition, things of that nature. And then on the procedural piece of this, so I think that on the procedural piece of it, I think that the federal government did fairly clearly err, but it's readily fixable. So again, the statute says that to exercise this authority, that orders to mobilize National Guard under 10 U.S.C. 12406 shall be issued through the governor of the state. But what happened here was the Pentagon, after the president's order, sent their directives to the chief National Guard officer in the state, often called the Adjutant General or the TAG. And so the governor of California was bypassed. I don't think that the statute can properly be read to give the governor any sort of authority to say no to the president. But anyway, the governor was bypassed. So I think that this is not ultimately going to help Governor Newsom very much for two reasons. One is that under California law, the Adjutant General is essentially substituted for the governor when it comes to issuing orders to the National Guard in California and whatnot. And then second, the president can cure this with the stroke of a pen. Or the Secretary of Defense, right, can just issue a new order, right, and just send it to Governor Newsom, who then under state law would immediately send it to the Adjutant General, and so that issue goes away. So I think that the more salient one is the rebellion one, and I guess I'm skeptical that I think that he probably would win because of some discretion. And Ned, I know that you've been reading about this, and you just sent me a note I just saw before we hopped on, but I guess my own sense is that I think that, I think that these are, reasonable arguments, I think, can be made on both sides. But I think that the outlook is probably not great for the state on this issue. Would you agree with that?
Ned, I think you need to unmute.
Sorry, folks. Yeah. My big picture question with respect to all of this is, is there anything as a practical matter within our legal system that can stop Trump from potentially using or abusing this power if he is so inclined to use or abuse it? And, my analysis of that, not that I necessarily like my own conclusion, is that the judiciary is going to be very reluctant to issue any kind of injunction against the President of the United States in his authority as Commander-in-Chief of the Armed Forces, as Dakota, you correctly say, when the president is invoking that military power. There's case law in the U.S. Supreme Court, going back to the War of 1812, as well as other case law in lower courts. For example, when President Obama decided to issue a targeted strike against a U.S. citizen who was, President Obama concluded was part of Al-Qaeda. There was an effort by the ACLU to get an injunction against that military strike, and the courts basically said they can't sit in the Situation Room with the commander-in-chief and basically veto a president's decision of the use of military force. We could talk about other cases as well. So it seems to me that under our constitutional system, the only practical constraint on the president is Congress. And maybe this is where I come at this as an election law person, and that the fact that our electoral system is causing us not to have the kind of Congress that's willing to stand up to a president and exercise its independent role in terms of supervising abuse of presidential power. But I don't think we can really expect the judiciary to solve our problems for us. I mean, again, I agree with you, Dakota, that this doesn't qualify as a rebellion under the language of the statute, but I think the president is going to be entitled to interpret the statute without judicial oversight. And part of our legal system is that sometimes other instruments of government other than the judiciary get the final word as to what the law requires or what the law means in particular instances. So, I don't know if others share that view or differ from that view, but that's sort of how I'm seeing it at the moment.
Yeah, I mean, just to respond to that, I mean, it's interesting. So often in this conversation, the public conversation, also the legal conversation, people emphasize judicial deference to the president to make national security determinations. And there definitely is a good amount of that. What often gets left out of the conversation is that there's also a massive amount of judicial deference to Congress when it comes to use of force in the armed forces. There are more individual provisions of the Constitution that empower Congress to legislate on matters of national security than any other subject in the Constitution, from what I've been able to tell, last time I checked anyway. So, really there's a lot, there's a long line of cases, the Youngstown line of cases going back to Little v. Bareem during the founding era, where the Supreme Court has made clear that the president is bound by statute. When it comes to matters of use of force, assertions of national security powers. That's certainly not absolute, but the general rule, as the Supreme Court has made clear, is that the president is bound. However, when Congress it does not, when Congress legislates in an ambiguous way or does not anticipate circumstances by doing things like defining rebellion or opposition to the law or something of that nature, what that does is it's just an implicit delegation of a lot of discretion to the president to interpret those words. And I think just reading the briefing on this and reading the brief, from what I've seen in Los Angeles, I mean, certainly, political violence is not okay. And, I think I'm really, really concerned with, violence, the limited amount of violence we've seen used against ICE by people who are upset, right? Rather than just doing First Amendment, demonstrations, right? I'm concerned about that. However, that does not look to me like some sort of rebellion against federal authority. And it also just raises this question of like, well, at what point does crime or civil disorder or civil disobedience, right? When does that turn into rebellion, right? Well, unfortunately, Congress has not answered that question for us, and so there's a massive amount of discretion for the president. And I think a lot of just to to touch on where you started, Ned, even potential action by the president, which I think a lot of people would regard as not being faithful really to what the statute is about, and be acting in a way that people might find oppressive. Looking at really, really limited instances of violence against federal officers, right? To have a really expansive response, right, within a city or across the country, and doing things, that disrupt our civil military norms, that we don't, that law enforcement and public order are matter for local law enforcement. If they are overwhelmed, for state law enforcement, if they are overwhelmed, for the National Guard on state duty, which is not bound by posse comitatus and can do law enforcement, right? Like that's our default. That's our constitutional order. It's protective of liberty. But there's a lot of latitude here for a president who wants to militarize a response, right, to public unhappiness with how the federal government is going about executing the law, right? To, again, militarize the public space, normalize militarizing the public space, right? Which just tends to, just kind of suck power in a magnet way, right, to the president, to the federal government. And it just inevitably raises concerns about disruption of how we understand our constitutional order, and the government being oppressive. The one basis I think that I would see maybe for the courts as this litigation going forward, really to push back strongly on what the administration has done or might do, is if there's some issue of individual rights being implicated here. When you look at a number of cases, such as some of the post 9/11 litigation cases. So in Padilla, in Hamdi especially, so a number of these cases involved individuals in Hamdan. These are individuals who have Fifth Amendment rights to not be deprived of their liberty without due process of law, right? Or if we have a First Amendment free speech or free assembly, right, being implicated in some way, right? Now you've got that, right, going up against federal power, right, that's been, delegated to the president in statute, right, to use force. And so I think that kind of like whatever the circumstance, whatever is going on in the case, I think would matter a lot. As it stands right now, we just have a suit by a governor of a state basically saying like, hey, you took my National Guard, right, in a way that runs afoul of the criteria in the statute, right? And that strikes me as kind of a weaker case to push back on the president, right, than one where you've got an individual who can claim, Fifth Amendment rights, Fourth Amendment rights, maybe First Amendment rights, right, that have been violated.
Dakota, what you just said raised so many so many fascinating questions for me. And one thing I want to note is sort of the asymmetry in the branches of government's ability to be nimble, right? When we talk about Congress needing to act, perhaps to better define our civil military norms, that might take a long time. Court cases take a long time, whereas the executive can act, very quickly. But the question I want to ask you is, we've been here before, you cited some post 9/11 cases, but I'm really thinking about the federalization of the National Guard during the Civil Rights Movement by JFK or LBJ. How does this compare to that history?
Yeah, that's really interesting. And that's a really important, so the civil rights era and action by actually three presidents Eisenhower, Kennedy, and Johnson, is a really, really important part of the history of our country in terms of just the history of governance in our country, and the history of our country, and also the history of civil military relations in the United States. And so the bottom line was that during the 1950s and the 1960s, there were rulings by federal courts that southern states were in violation of federal law that protects Black folks in the South. And in a number of instances, the resistance was very explicit, very local, very, very vocal by Southern governors and local officials. And in a number of instances, local officials, state officials were using their National Guard, not just police, but National Guard in ways that were defiant of federal authority. And so those presidents invoked the Insurrection Act. In one of those, this actually 12406 was invoked in connection with that, but it was mainly the Insurrection Act. And I think that there's a really, really clear case there that the state of Arkansas and the state of Mississippi and other places were in violation of, they were in rebellion against the courts, against the Constitution of the United States. And they were definitely opposing execution of the laws, right? We had court orders that were directing them to do things, and we had federal law, and it was being defied. And so those presidents invoked the Insurrection Act, and they sent in federal regulars. Many of us have seen pictures of the 101st Airborne in Little Rock facilitating integration of schools. But what the insurrection invocation also did was it allowed the president to take the National Guard away from the state governors, put them on federal duty, and basically deny the states any sort of organized military ability to oppose federal authority, which is very much part of the founders' understanding of what they were doing when they, in the Constitution, gave Congress the power to give the president the authority to federalize the militia. That was certainly one of their concerns. So I think that was certainly well grounded. But comparing these, what's different about this is just the scale of it. I mean, there was a massive amount of violence in the South during the Civil Rights era, and obviously before, against African Americans, to terrorize them as part of the Jim Crow, to enforce the Jim Crow system that excluded them from the mainstream of civic life and economic life, just to do terror, right, through lynchings and burnings and attacks and whatnot. It was widespread. It had the support of local government authorities, state government authorities, right, the police, in many cases, the National Guard. I mean, that was just like heavy, oppressive action. And just, what in the law we'd say is just a massive fact pattern. Here, there are definitely some alarming images on TV that we've seen. However, I have not seen any assertions that, any of these crowds were, that it was more than, a couple dozen people in these crowds who were like throwing water bottles and rocks, or, and like some of these other videos that I've seen, where it's, presented as, okay, this is rebellion in Seattle or Los Angeles or violence or whatever. And, from the best I can tell from the shaky cell phone picture, this is like 4 people pushing and shoving, or spitting or whatever. And, that looks to me a little bit more like crime and some civil disorder. So I'm just straining to understand how 12406 is actually the right thing to do, much less, invocation of the Insurrection Act, much less to go beyond that to what White House advisor Stephen Miller threatened last month, which is unilateral presidential suspension of habeas corpus, which would be blatantly unconstitutional because the Constitution's text gives the power for suspension of habeas corpus to Congress. And additionally, would be, looking at the Constitution, I mean, I think that arguably the closest thing, the closest avenue that the Constitution allows to a condition of dictatorship in the country is habeas suspension, because it allows the president to order people to be detained without access to the courts, and without an allegation that they violated the law, right? I mean, it's just to deprive people of their liberty and throw them in a pit. And that can be one person, it can be millions of people. And I've, as I said, when I was doing a radio interview the other day, this argument from the administration, well, Lincoln did it. Well, number one, it was ratified by Congress later, but even when Lincoln did it, you know, I call that argument basically like saying like, well, my great grandfather stole a horse, so I can steal all the horses I want, right? It wasn't constitutional then. It doesn't make it constitutional now because it's directly contrary to the Constitution. So I just look at, you know, the level of violence we're seeing now against federal officers, you know, and while I object to all of that, I don't think it comes anywhere close to what actually is necessary for any of these authorities, much less habeas suspension.
Dakota, I want to preface my question by noting that I'm the grandson of Irish immigrants. None of my grandparents are born in the United States, so I'm very strongly pro-immigration. But to play devil's advocate, you were comparing the scale of Southern resistance to federal law in the 1950s and 60s to the scale of the current anti-ICE protests. But don't we need to view this in a wider lens? According to the government's numbers, we're looking at about 14 million unauthorized immigrants in the United States. We have years of states like California who have thwarted federal efforts to enforce federal immigration law. I think there is a case to be made that this is an issue that is at the very top of the public's concern. We consistently see strong public support for enforcing federal immigration law. Isn't there a risk here that if the courts play a very aggressive role in restraining the president's ability to enforce federal law in a context where there is at least some degree of violence in resisting the president's efforts, that this would establish a precedent that down the road could be very detrimental to the powers of the federal government in general, when you might well have a Democratic president years down the road facing flagrant violations of federal law, and courts could potentially then use the precedents that are established today to restrain that president. So I just raised the partisan issue because this seems to be a theme in this polarized era where we see with nationwide injunctions, which were bemoaned by Democrats and celebrated by Republicans when Biden was president, and now we're seeing the exact reverse. And it feels to me like it starts to escalate. So what concerns do you have about a court ruling that's overly aggressive in terms of what that might do long term to the president's ability to enforce federal law?
Yeah, so it's so I certainly think that that's a very legitimate issue and concern. You know, we always have to think about the precedential power of you know, judicial decisions, right? You know, or you know, I think it's a real issue, and so operating here, I think, are a couple, you know, really interesting legal questions. So one is the assertion that we've seen from, you know, we've seen it from Governor Abbott in Texas, and we've seen it from the Trump administration and from others, that that the migration into the United States of a large number of people across the southern border in particular, right, is an invasion. And you know, therefore, this allows invoking a variety of authorities, right, to deal with that in you know, potentially even in just a, you know, like a militarized response to invasion ground, right? Like not even necessarily enforcing the law, right? Just like using military power, right? Like that's the most extreme version of this that I've heard in the conversation. Like, you know, this isn't, you know, the country has been invaded. You know, don't even bother with federal law enforcement, right? Just like get the 1st Infantry Division and the 10th Mountain Division like into the streets in America and just use like hard military force to just go grab them and, you know, remove them from the country. So, you know, that's one issue. And so I think we just need to figure out kind of what's invasion. And there's been a really interesting conversation among scholars and in a couple of cases, some courts have weighed in on this about what is invasion. I think there's a strong case to say that the way that the framers understood invasion, and we've understood it through most of the country, is some sort of like organized, violent group activity, right? Like it's you know, and it's not just a, you know, a flow over decades, right, of people migrating into the country in an undocumented way because they're seeking economic opportunity, right? Or they're fleeing, you know, they're fleeing breakdown in civil authority and violence in their home countries, right? And my sense of it is, the vast majority of the people who have entered the country, in an undocumented way, that's exactly, they're economic migrants, or they are fleeing horror in their own countries, right? And yes, they did not comply with the law when they entered the country, and I think that is a legitimate concern. And I also think that the permeability of not just the southern border, but our northern border as well, I think that that's a real issue from a national security standpoint. And I understand public frustration with having something like 12 million people, right, who are in the country who are undocumented, and the permeability of the borders. I completely get that. And unfortunately, we've had a bipartisan failure that has now reached, it's into its third decade at least, right, to have a rational, cohesive, appropriately resourced approach to immigration, the border, all this stuff. And, at the risk of just kind of, being cavalier about it, the greatest, I think that the biggest mess up, if you will, or failure to meet the moment, let me put it that way. Let's pejorative language, failure to respond to the policy dilemma, right, that we've seen from the Republican side, is not wanting to resource the system, right, enough to deal with, so not enough immigration judges, not enough, investigators, all of it, right, to deal with all the cases of undocumented folks in the United States in a timely fashion. I mean, if you've spent any time on this, and I remember, a number of cases when I clerked 15, 16, whatever years ago it was, right? I mean, there are people who came, people who are, smuggled into the United States by criminals, who then, managed to get free, set up their lives in the United States, become exemplary residents of the United States in every other respect. And it took the government like 12 years to resolve their case. And then there's finally a hearing, and they decide like, oh, okay, you're here illegally, we're deporting you. I mean, just the incompetence of it, right? And that's, again, it's just not fully resourced. And then I would say the failure to meet the moment that I've seen, again, I'm just wide generalizations here, right? On the Democratic side is a unwillingness to deal with the permeability of the border, and to just to acknowledge that this circumstance of having so many undocumented people here and borders that are not being fully controlled reasonably induces massive anxiety in a really large part of the population, right? And so unfortunately, it's been a bipartisan failure. There have been a number of legislative efforts under both Democratic and Republican efforts to try to respond to both pieces of this, like resourcing the courts and the investigative and the border, and also I think dealing in a humane way with dreamers, right, who were brought here as children and they made no error of their own, right, or people who have been here, who are fleeing horror and have been exemplary Americans in every way, except anyway, there's been a lack of responses, and we got close with legislation a number of times, and the partisan politics blew it up. And I think that the danger here is that just the level of just kind of public frustration leads to, at some point, national leadership that takes really drastic action, right, in service of that public sentiment. And I recall here a comment that Justice Souter made at an interview, I believe at his alma mater, which I saw just a couple of weeks ago. It was a wonderful recording, and he was expressing his concern, and this was in 2010, about the future of the republic. And he said, when you study history of how republics have cracked up and succumbed to authoritarianism, one of the major ways, and he cited the ancient Roman Republic, was at some point the problems of the country are unaddressed for a sufficiently long amount of time, and the public gets sufficiently stressed by it, and then fraught with massive disagreement, that at some point the public, a sufficient part of the public says to somebody who doesn't care about the law, just fix the problems. And that's you study how republics have cracked up into authoritarianism, and that is a really, really common feature, right? Is that it's it's pretty rare actually that's just like some military coup. Usually there's like a desire among a part of the population, a majority or a sizable minority, to say we want problems fixed, and somebody comes along and says like, well, I will provide you the solution you want, right? But in return, the deal is the Constitution is shredded, the laws are crushed, and you get a dictatorship, right? Like that's the con. That is the central authoritarian con, right? Is I'm gonna like, here's a problem, and my solution is dictatorship, right? And I think that that's obviously a concern that animates a lot of people, and either like, partial dictatorship, or full on awful dictatorship too.
Dakota, hi. You referenced just a little bit ago, we're kind of switching topics a little bit here, but the suspension of possibility of the suspension of habeas corpus, and that I recall the administration referencing that some time in the past, and I was at the time, I think, having difficulty imagining that the federal judiciary would say that that's okay. But now I'm kind of wondering if that is also your sense. And I know you mentioned, Congress could also authorize that, which maybe that's a possibility. But I was curious about what you thought about how realistic that might be, that could pass legal muster.
Yeah, so I'm not a habeas specialist, so I need to caveat that, as I tell my students, right, like as a good lawyer, you always need to, as a matter of professional ethics, recognize when you lack deep expertise on a topic, right? But I would say, just based on what I do understand about the issue and reading people who seem to know their stuff, I think there's a pretty good chance that the Supreme Court would strike down some sort of unilateral presidential suspension of habeas, especially because Justice Barrett is an expert on habeas and has written extensively on it, from what I understand, and said pretty clearly that Lincoln's suspension was unconstitutional. So I think that, and I just can't imagine Chief Justice Roberts going along with that. So I think that would probably not work. I also think that suspension of habeas by Congress, I think, is also not likely, because number one, the majorities are, even if the president pushed hard for it, and generally speaking, right, the Congress has been very pliant for President Trump. This Congress has been. However, having said that, this is the narrowest House majority in terms of percentages in 100 years. Basically, they have a 2-vote cushion. In the Senate, the vote is only 3 or 4 votes, depending on the circumstance. And this is so.
Well, you need to overcome a
is
filibuster
such a
anyway
problem.
in the Senate. So, but the Senate's not going to suspend habeas corpus. So
Yeah, right. With the filibuster, and there's no way Rand Paul's voting for that. And yeah, no. So I just don't see that. I think what does worry me is kind of like, action pursuant to a number of these statutes, right? Or this protective authority that they're asserting, which just is like, it's kind of like creeping partial habeas suspension. It's not full habeas suspension, but they're detaining people in ways which are not, fully reflective of due process rights. Or maybe Congress tries to do some sort of like partial suspension. I mean, even in the post 9/11 Guantanamo cases, I mean, even there under the Detainee Treatment Act of 2007, 2008, there, in 2010, there are restrictions in there on habeas. And it's not habeas suspension, but there are restrictions on habeas rights for non-citizens who are held at Guantanamo Bay. And a lot of civil libertarians of the right and left were enormously unhappy about that. Like, do not touch habeas because it protects all of us from the government. But I think that's what would work. Kind of like I think that invocation of 12406 is basically soft insurrection invocation, Insurrection Act invocation. And so what worries me is some sort of like soft creeping habeas suspension.
I guess.
And
go ahead, Matt.
So Ann mentioned the word nimble a little bit ago, which was kind of a word that was in my mind. But maybe the courts would be a little more nimble if in terms of reacting to a habeas suspension.
And I don't purport to be a habeas expert either, but I guess my thought on that is that I agree with you that the court, I don't think, would tolerate a unilateral presidential suspension of habeas corpus, despite the Lincoln precedent such as it is. But the scope of habeas pertains to detention and custody. It doesn't apply to what might be termed kinetic use of military
Mhm.
force. So, I come back to the example of Obama and al-Awlaki, right? I mean, if the ACLU had attempted to assert a habeas claim in behalf of al-Awlaki as a way to stop, the targeted assassination of al-Awlaki on presidential order, I don't think that would have worked to protect al-Awlaki. But I don't think that the habeas is a shield against military force. It is a shield against military custody, I think, like
Yeah.
civilian custody, but I don't think it has applicability to, what we would conventionally use term as the use of military force. And I think in my mind that comes back to, kind of a fundamental distinction in my mind of the comfort that the judiciary will have to constrain presidential power. You mentioned the Youngstown famous steel seizure case, which it is true that President Truman said that there was, the Korean War. Again, that was a period of American history where we actually thought a lot more about whether Congress actually declared war or whether it was just military force without a declaration of war. But Truman attempted to assert a military justification for civilian seizing of the steel industry. But it wasn't the military seizing of the steel industry. It was being run through the Secretary of Commerce, as I recall. And so I think the judiciary is willing to constrain presidential invocation of civilian authorities, even when there's a national security or military related justification, but it's not actually the invocation of military authority. And for that reason, I think I mean, again, this is a prediction, and I could be proven wrong, but I think we've been talking about immigration, and we've been talking about presidential declarations about what is the predicate for trying to invoke various so-called authorities. And there's been a lot of discussion over the last few months about the so-called Alien Enemies Act and whether or not that would be a justification for this very aggressive immigration detention, including sending people to El Salvador and so forth. And I think the judiciary is going to be a lot more comfortable, as it already has been, in basically saying, no, President Trump, you can't claim that there is an invasion that justifies the exercise of military authority to send ICE agents to do X, Y, and Z, because the ICE is not the military. ICE is still part of, as you said, Dakota, the civilian police power that exists at the federal level. And one of the things I thought was most vulnerable about Judge Breyer's decision that's on appeal in the Ninth Circuit, and this was a point that was also made by Jack Goldsmith in his analysis on this executive function subsec, is the precedent that Breyer, and this is not Justice Breyer, this is Judge Breyer, tried to rely upon to claim judicial authority to second guess Trump's claim of a rebellion was an immigration precedent, not a military precedent. And I wouldn't be surprised if the court draws a sharp distinction there between judicial review of immigration civil authorities versus judicial review of presidential use of military force. I don't know if others agree that that distinction is going to be salient or not, but that's sort of what I'm predicting at the moment.
Yeah, I would generally agree with that. On Youngstown, you're right, obviously, that it was the Department of Commerce that seized the steel mills on presidential order, but behind that was an assertion of Article 2 Commander-in-Chief authority, right? And the Supreme Court and their spread of opinions, and especially Justice Jackson in his concurrence, right, talked about the Article 2 Commander-in-Chief power up against the presumption that Congress needs to legislate here. So that's certainly still operating, and so that's why I do go to the Youngstown case and that line of cases. And I think you're right about immigration versus the kind of domestic use of force scenario that we're talking about. I do think that was a weak point with Judge Breyer's opinion. What worries me, related to this is some sort of just some sort of normalization or acceptance, be it judicial or otherwise, right, of just like kinetic use of force inside the United States under just assertion of Article 2 authority, right, to protect federal agents, protect federal property, respond to invasion, right? So, if you're just basing it on the president's Article 2 authority, that's not pursuant to an act of Congress. And it's the worst possible scenario, right? It's like kinetic, which means just violent military force inside the United States in a domestic setting. It's just an authoritarian nightmare. And I think it gets especially difficult,
Well, sorry, but I mean, I agree.
Yeah.
I mean, I am as troubled as anybody about what Trump is doing. I hope everybody understands that. But I do, and President Trump is no President Lincoln. And you're right to distinguish the scenarios. But we do have to acknowledge that President Lincoln used force not just to suspend the habeas corpus, which was a problem and a separate thing, but obviously he had to make judgments about whether to use the federal armed forces on U.S. soil against what was genuinely the rebels, the Confederate rebels. Now, I don't think of Gavin Newsom as a rebel, and I don't think the state of California is in rebellion, but the jurisdictional issue is who gets to make that call. Does the president get to make that call subject to the impeachment power of Congress, et cetera, or does the judiciary get to constrain a presidential determination that he's going to invoke military force, as momentous and as awful as it could be, on U.S. soil against U.S. citizens and U.S. officials? We can clearly not like what a particular president wants to do. Obviously the Confederates didn't like what Lincoln was doing, and history, I hope, has shown that they were in the wrong. But who gets to decide whether we like or don't like what the president is doing, and can the judiciary say no to the president?
Mm-hmm. Mm-hmm. Well, they certainly, can on national security matters, basically, if you've got the case presented in the right way, right? I mean, they have, and again, the Youngstown line of cases, and other settings, the Supreme Court has said no to the president on national security matters, and they will. But again, it's just, the facts and the law of the particular case matter a lot.
Has the Supreme Court ever said to the president, you may not send troops into this situation, or you may not deploy military force in this situation?
They haven't reached that. No, but they have struck down presidential orders. And in the Hamdan case, it was an order to the military to try detainees. It was unlawful under statute under the UCMJ. Little v. Bareem, they invalidated President Adams' order to the Navy as not an explicit violation of statute as under Hamdan, but just an implicit violation of the statute. So there's certainly grounds there, but they haven't invalidated something like actual deployment. But what worries me about this assertion of Article 2 protective power is that it can be used aggressively and I think in just a pretextual way, right? I mean, so if you can send civilian people, civilian federal officers, right, to enforce the law into all sorts of different places, right, in the country, and you can do that legitimately, but then you wrap them in military forces, right, and under a protection argument, right? So imagine like one or two ICE agents, right, with like a force of 20 or 200 or 2,000, right, Marines around them, right, going around. I mean, it just inserts military force into civilian settings in a massive way, which may look facially legal, but it's, I think, nothing like we've understood our constitutional order to be. It's enormously worrisome, and I certainly hope that things don't go in that direction. And frankly, to end on a positive note, I mean, despite the violence that we've seen, right, against ICE and others, I've actually been really heartened by actually how little violence there has been, given the level of public concern about the brutality associated with a lot of ICE actions, and a lot of other concerns, right? I mean, look at everybody who's demonstrated, right, this last weekend and over recent months, and the number of people who've been violent, right? What is it like? Is it 1/10 of 1%? Is it 99.9 or is it 99? That's a really small amount of violence, and I'm heartened by that, right? That the response of the overwhelming majority of Americans who are concerned has been First Amendment protected conduct and not violence.
Thanks for that positive note, Dakota. We are out of time today. There's plenty more we could continue to discuss, but we'll hold off for now, with great appreciation for how you've contextualized the particular issue that's being litigated right now, as well as giving us some broader understanding of this general area of law and government at the moment. So, Dakota, thank you so much for joining us today, and many thanks to the rest of my election law colleagues for being part of this episode of Law and Democracy. Thank you.